It's good to be with you. This is going to be a crash course in some considerations in basically three areas. Picking the right entity, picking your partner, and then key documents. And this, again, we're going to touch on things at a very, very high level here. And a little bit about the firm. As Kelvin said, our firm was started in the 1960s in Silicon Valley. It grew up around that whole tech thing that was going on down there, and it's now expanded to over 1,000 lawyers in 15 or so offices, basically in every market where there's a concentration of tech or life science companies, high growth companies. So in the early days, we formed companies like Google and took companies like Apple public, and that was way back when, before, or when I was very, very young. And then 3 years ago, the firm decided to open a Salt Lake City office and asked me to help with that and opening the corporate group. I've been in the market since the early 2000s. So it's been fun. And to give you a little bit more background about the kinds of companies we work with really early stage companies, even some at formation, all the way through very mature public companies. And we handle all their legal needs along the way, whether that's financing, M&A, licensing, any kind of IP issue, litigation, employment, the whole gamut of what companies might experience. And we kind of grow with companies as they get bigger and more sophisticated and more complicated. So my personal practice is I represent, again, early stage companies to really late stage private mature companies. I often tell people I just represent a lot of the billboards between here and Provo. That's a fairly good representation of some of the companies we work with. On the life science side, work with companies like Halia and Kirza, Seek Labs, and others. Cartera, which is an old U of U spin out. And then on the tech side, companies like LVT and Chatbooks and all sorts of Entrada, Weave, companies like that you might be aware of. So we're going to tackle, just like I said, three topics quickly. Choice of entity, and I threw this together in about 5 minutes yesterday, so if there are typos, they are mine. Picking your partners and key legal documents. Choice of entity. Typically, we would say if someone came to us and said, I want to start a company, we would say, okay, let's do a Delaware C-Corporation. But that's not always the answer for your company at the beginning. I just want to go over some of the things you would be thinking about in making that initial decision. First, LLC. LLC is a creature of state law. It is, so you have to find a state that recognizes an LLC. The first state to create LLCs was Wyoming back in the day. Utah has them, Delaware has them. I think probably every state has them now. On the tax side, so you're generally thinking about taxation, liability, and then sort of structure and flexibility around structure. So LLCs are treated as a partnership under federal tax law. What that means is they are a pass-through. What that means is the IRS ignores largely the entity itself as a taxable vehicle or entity. So we say single layer of tax, meaning if any of you are in a partnership or an LLC, you get what's called a K-1. It tells you what your allocated income is, and all the tax activity happens at your personal level, not at the entity level. So that's one benefit of an LLC. They're incredibly flexible when it comes to structuring them, classes, voting, non-voting. It's sort of anything goes how you want it. It's all a creature of contract. However, there's no QSBS treatment, and if anything, just leave this little presentation with that QSBS concept in mind. Qualified small business stock is a beneficial tax treatment to investors and founders of certain companies where they can shield their gain up to certain limitations. If the company that's issuing the equity or the stock is qualified, if it's qualified small business, a founder with no basis can shield $10 million of gain. It's about $4 million, give or take, depending on your tax bracket. It's the greater of $10 million or 10 times your basis. So if you're a venture fund and you put $10 million into a company and get qualified small business stock back, you are shielding $100 million of gain. This is very important for investors. LLCs cannot issue qualified small business stock. So that is a consideration depending on where you're going to take the company, and we'll get to that in a second. So that's LLCs, partnerships, kind of the same thing, but we almost always see LLCs. Corporation, you can only form a couple different kinds of corporations. Those are all creatures of state law. Remember, LLCs, corporations, the state recognizes that entity as an entity that they legally recognize and assign rights and obligations and other things too. The S and the C is simply a federal tax designation or election. Every corporation that's formed is a C corporation unless it makes an S election. So let's talk about an S corporation. If any of you have run small businesses, your accountants have probably told you to be either an LLC or an S-Corp. We won't get into the reasons why. I think probably the vast majority are S-Corps because there's some better tax treatment there. But it's taxed like a partnership, so it's passed through. It's structurally rigid, however. You can only have a single class of stock. You can only have so many owners. And if you violate any of these S-Corp rules, you automatically bounce out of S-Corp status into a C corporation. And you cannot issue qualified small business stock. So I, in my practice, rarely, if ever, see S-Corps as a starting point. Might be an LLC. C-Corp. C-Corp is just a traditional corp. Again, you do nothing but form the corp, and it's a C-Corp. 2 layers of tax, meaning the entity gets taxed on its profits, and then the owners get taxed on any gain they receive relative to their equity, whether it's a dividend or a sale of that equity. There is some structural flexibility, actually a fair amount, but not as much as an LLC. And you get qualified small business stock treatment. So this is probably the vast majority of our clients, even from the start. You say, well, geez, 2 layers of tax seems tax inefficient. The reality is companies that are starting down this path, this high growth, racing towards some sort of exit liquidity event, they're never profitable. So there is no sort of concern about corporate level tax. They run a lot of losses, and they can accumulate those losses and offset those against their gain. And they don't declare dividends. So they're not generally distributing out cash to their investors. So there's no concern about it being tax inefficient from the perspective of the owners of the company. They are looking for one liquidity event, which is when the owners are going to sell their stock, hopefully, either into an IPO or an acquisition. And if they aren't, it's an asset sale, and there's been some distress around that company, and there's usually enough losses to cover any sort of 2 layers of tax. So what are you thinking about, though? If you come to me and say, I want to start a company, I'm going to ask you some questions right out of the gate. How will the entity be funded? And what is your long-term goal? Are you funding it out of your own sweat and your own capital? And you might take a little bit of money from friends and family, but largely you're going to, and you can get to cash flow positive pretty quickly, and this is going to be a lifestyle business, and you hope to be pulling out as much cash as you can as you go along. That's going to be one question. If that's the case, you might be leaning toward an LLC. You're not even thinking about selling it. This might be a business you hand down to your family or your kids or whatever. Then probably you're going to start as an LLC because the 2 layers of tax will become relevant quicker. If the entity will require outside capital, who are the target investors? This is the question. If you're going to raise from any institutional investor early on, you'll hear them called seed funds, angel investors, rich people, venture funds, okay? Who are tax savvy and appreciate qualified small business stock and the benefit of that. They will absolutely insist that you are a C corporation. This isn't negotiable for them. You will be a C corporation because they want that QSBS potential. It does not mean they're going to get it. You have to hold the stock for 5 years, and there's a number of other requirements you have to meet, but they like the idea of having at least a shot at getting QSBS. And in fact, those investors aren't going to want you to be distributing cash. They aren't going to want you, this might sound a little bit strange, but generally they're not thrilled with you actually generating a profit too early because that means you're not growing as fast as you need to. Now that's shifted a bit the last 3-4 years. Now there are some, there's a sort of a mandate to get to cash flow break even and those sorts of things, but still the whole goal is growth in that hockey stick, sort of showing investors and buyers that there's still a huge market out there that can be addressed. So they absolutely will insist that you are a C corporation. So you might be thinking, oh man, I started as an LLC. I thought it was just going to be a lifestyle business. And all of a sudden I needed a lot of capital and there was this huge market that I was going to go after. Can you convert from one to the other? Yes, you can. There are some tax considerations and you can start your qualified small business stock treatment at the time you convert. So not all is not lost. And in fact, some clever entrepreneurs, they start as an LLC and then they convert when they're below some of the thresholds you have to stay below and hoping and getting above the 10 million shield because they want 10x something more. So if their basis is, for example, 2 million at the time they convert, now they're looking at a $20 million tax shield. It's a risky game, but some people play it and win. And so this other question, how soon, if ever, will the entity be profitable? Again, the vast majority of our clients are Delaware C corporations. Why Delaware? Well, Elon Musk has sort of kicked some dirt on that a little bit, but still it's viewed as it's the state with the most established body of corporate case law and statutory law. It's historically viewed to be very corporate friendly. They have judges that do nothing but cases involving corporations, and so you aren't getting a judge who one day is hearing a case about a real property dispute and the next day about a corporation. This is all they do, every day, all day. They've been in the news the last couple of years because of some decisions that seem to be less corporate friendly. The legislature immediately jumped in and started amending its statutes in a way to override the courts. That's the classic legislative judicial branch battle, which is healthy. So we still see the vast majority being formed in Delaware. We all as lawyers know what those documents mean when they're in Delaware or governed by Delaware. You are seeing some companies going to Texas, and Nevada's always been sort of a spot that some people think they should be in because of the friendly corporate statutory law there. Okay, so that's up front, and always you talk to a lawyer, and then you want to talk to your accountant. You want an accountant to be advising you and being in the loop and in the conversation about the kind of entity that's best for your business. We don't presume that you are going down what we call the VC path, the venture capital path, but if you are, in fact, it's so common that we have a automated system now that can generate all your documents in about 10 minutes if you fill out a little questionnaire online and get you filed in a day, basically. So that's still where most of the action's happening. Okay, consideration in picking your partners. This is very important. Who you can do business with. 6 things to think about. What does your company need in terms of human capital? What does your business need out of the gate? Sweat equity, human capital. What are you good at? What are you not good at? What does the business absolutely need even to get off the ground? So in my world, I often see sort of the visionary business, idea type, and then a technologist riding shotgun, right? Those two. That's kind of on life science, the scientist and the operator. That's kind of what we see typically. You don't need a lot at the beginning, but you definitely need to think about who your partners, and partners in this sense, we're just talking about, in quotes, partners. These would be founders if it's a corporation. If it's an LLC, they're members. But this is partners in terms of who you're partnering with to do business. What will your roles and titles be? You pick them right up front. Who's the president? Who's the CEO? Sometimes one person's the president, CEO, secretary, treasurer, and everything else. That's okay. Doesn't mean you're good at any of those things. Just means that's your title. But you need to define that. What property will you contribute to the company? This is really important. If you've been working on business plans, ideas, if you've created something, you need to identify what that is, and that needs to get assigned into the entity right up front. And what are you contributing? Are you putting in just sweat equity? Are you putting in some cash? But if there is actual intellectual property or other property that you both view as being the company's and important to the company's developing products and ideas going forward, that needs to get into the company. We're dealing with this right now. Shockingly, sometimes founders don't get along after a few months or a few weeks or a few years, and they divorce. And the first thing we look at is, did you guys all sign documents assigning all of your rights to this idea and property to the company? Or do we have an issue where one person can walk out the door and at least argue that it was never the company's? So that's important. How will you split the ownership pie? You probably say, well, 50-50. Well, or 33-33. Sometimes that makes sense, sometimes it doesn't. But you have to have that awkward conversation up front. It's kind of like going to dinner. You might as well figure out who's paying for the bill up front and not wait till the end of the dinner and how you're going to do it. Just tackle it up front. Are we splitting this? Are you paying? Am I paying? But you got to work through this early, and it's one of the first things you should be thinking about. How much time will you each contribute to the business? A lot of businesses get launched while you have a day job, right? You're moonlighting. You're doing things in your garage, in your den. You're staying up till 4 a.m. working on this idea that you have. And maybe your partner or your co-founder is too, or maybe they have a full-time job, or maybe they're working full-time on this. What's their expectation of each other? Are you okay with each other moonlighting for a while? Sometimes you have to, right? But what's the expectation? And at some point, are you both going to roll off your day jobs, for example, and go at this full-time? The reason that matters is because up front, you give yourselves your ownership interest, your equity. If this is a corporation, it's stock, right? So right up front, you're going to take ownership in this company. And what are you committing to give for that? Which relates to vesting, I'll give you one example. One example is you both say, okay, 50-50, cool. That's it, 50-50. There's no vesting. There's no anything tied to it. You start the business, you get a year into, and your co-founder says, I'm done. I'm out of here. I've lost the passion or whatever. And they walk out the door. Well, guess what they walk out the door with? 50% ownership in the company, right? And it is still 50-50 until things change in the future. That's not usually a good result for anybody. And so most of our founders will agree up front to at least a time-based vesting schedule, which means you get your equity today, but the company can claw it back if you, to the extent you have not vested at the time your services terminate. Usually a 4-year schedule, usually some sort of 25% 1-year cliff, meaning you got to be there at least a year to even keep anything, and then monthly or quarterly thereafter. It can vary. Sometimes founders come to us and say, we've been at this for 2 years. We feel like we each already have earned 50%. Great. Then we'll vest the balance over some time period. But this is really, really important. I've heard many times, yeah, but we really trust each other. We don't need to document any of this. Yep. You've all had relationships like that, and then a year later, you're really regretting that you had not sort of documented things. People change, circumstances change. People change when things start to get valuable. And so we say, we know you love each other, and you would each step in front of a train for the other, and that's beautiful and wonderful. Let's document some vesting. If you're in a closely held partnership where it's not going to go down this VC path, then you'll also negotiate things like, well, what if one of us dies? What if one of us gets divorced? What if one of us doesn't commit or continue to work on this thing full time? Should there be other events where we can buy the other one back? How do we feel about, the other getting divorced and the spouse all of a sudden showing up one day with half of the equity and saying, I'm all in? Usually people aren't very excited about that. So we can write in a lot of sort of different what ifs. Those are for closely held partnerships. If you're going down the VC path, it's usually just time-based vesting. Let's go. And things sort of play out over time. All right. Key legal documents. The purchase agreement. Napkins don't do. Emails, we prefer not. Your ownership be documented in an email and nothing more. There needs to be a set of documents up front that show what you are all putting into the company, whether it's cash or an idea or nothing, that's okay, and how much ownership you're getting back, signed by the parties. That's a really important document to have up front. You would be surprised at how many companies sort of launch out into the ether and they've never gotten around to documenting any of this. And then years later, things are very valuable and memories all of a sudden go faint or change, and you've got a problem on your hands. So then we have to go back and look at how is it reported for tax purposes and all sorts of other things to try to figure out who owns what. The next key document is an invention assignment and confidentiality agreement. The invention assignment is what it is. You are assigning, each of you, all of the founders, whoever they are assigning all the rights, title, and interest they have into anything related to the company as of that point in time. And then it says going forward, any work that they do on behalf of the company is automatically assigned or is the property of the company. It's a really important document that sometimes gets missed. The confidentiality agreement goes hand in hand with that, and this is you just can't share confidential information with anybody, with some exceptions. In states like California that do not allow for non-competes and non-solicits, this is what you hang your hat on as a company to protect the company's secret sauce. In the event that somebody leaves and you're concerned they're going to compete against you in some other capacity. So the confidentiality agreement, they're pretty standard. Our system takes that agreement, the invention assignment confidentiality agreement, and it tailors it for all 50 states. Because every state has its own, it's all state statutory law, has its own law on, or sometimes just case law, but on non-competes, non-solicit invention assignment. What the language has to say, what's included, what's not, can you moonlight, can you not, how far-reaching can the company be in capturing what it thinks to be its property. Non-compete, non-solicit, we could debate for hours the pros and cons of this one. If you remember maybe 10 years ago or so, a debate raged here in Utah, even up at the Capitol, about non-competes. California famously, again, prohibits non-competes, and they will tell you, people in Silicon Valley will tell you that actually spurred and forced people to compete and just to innovate, not sit back and try to keep people out of markets and different verticals, that it actually led to great innovation. Utah, that proposal went up to the Hill a while. It's been a while now. Old industry fought back and said, wait, we invest in these people, we train them. We don't like the idea that they could, the day after we train them, go across the street and compete. The tech side of the community bust people up there in T-shirts to say we don't want non-competes, non-solicits. We ended up with a 1-year maximum for non-solicit, non-compete. I would still say the vast majority of my clients still have these, and they have at least the founders and then key employees sign them as part of the onboarding package. Means if you leave the company, you can't compete for a year. You can't solicit employees, you can't solicit customers. But there's a good debate around that, pros and cons of that. And then the last one I put in it's a really sort of generic bucket, but shareholder or operating agreement. Operating agreement refers to if you're an LLC, you have this one extremely unnecessarily long agreement that governs all the rights and obligations of the members, the owners, and their economic rights, et cetera. If you're a corporation, it can be a shareholder agreement. This would be speaking to some of the things I talked about before. Are we going to have rights of first refusal on each other's transfers? Can we transfer? What if we die? What if one person wants to sell? Can I sell alongside them? Those types of things. With our corporations, we don't see shareholder agreements, but with closely held companies, we do. As the company then goes out and raises money from venture capitalists, they then start imposing agreements on the founders. They start saying, you're going to vote your shares a certain way in certain circumstances. You can't transfer your shares unless you let us buy them first. They may come in and look at your vesting schedule and say, you only have 1 year left. Well, we're only going to invest if you add some vesting back on. We need to know you're going to be around for 2 or 3 years, for example. So at the time of financing, there's about 5 key agreements that get negotiated as part of a package. And so those are some of the key legal documents up front. Some of this is very much boilerplate. Others is very bespoke and tailored to that particular situation and those founders and what they care about and what they think is fair. All right, I flew through that. When I teach this down at BYU in my class, that's about an hour and a half long chat. So I'm going to pause and just see if anybody has any questions. And there are no dumb questions. If something didn't make sense, feel free to ask. I'm happy to clarify.
Of course, we would take an hour and a half at BYU and only half an hour here, though.
Yeah,
because they
much
understand.
More efficient. Yeah,
they get it.
Touche.
Hey, I'm a BYU grad, so I can make fun of them.
And he's saying that to a double
back
cougar.
Here.
I'm a double cougar. I heard a boo over here. Was that you, Chad? Oh, okay.
Can you share more details about companies that are going from like this slow growth, they've been growing like 5% every year, to entering into a hyper growth company, and that transition from a legal perspective?
So slow growth to hyper growth. And is the question like, are you going to now go out and raise funds to fuel that hyper growth?
Yeah, exactly.
Yeah. So if you make that pivot or you naturally fall into that pivot, the question is, how are you going to fund that growth? Some companies are able to fund that growth through debt, whether it's an SBA loan or some other non-dilutive financing, and that's something you should always look at if it makes sense for your business. Others, really the only path is to raise equity, raise capital from investors. From a legal perspective, if you've had this closely held business and it's just you and a buddy and you're not being really careful about your docs and, you're just sort of doing your business and bringing in the money and splitting it, that's the time to get pretty serious about your legal documents and your governance and positioning yourself to go out and raise money. And so, for example, if you were an LLC and you've been doing really well, but now you need to put your foot on the gas and you're going to go talk to VCs, then we're going to talk to you about, okay, it's probably time to become a corporation. Here's how they would expect you to look in terms of vesting and other things, and we sort of just redo, we reposition you to go out so you look familiar too and are something that they would be willing to invest in from a governance and legal perspective. Sometimes we don't pull the trigger on those documents until you've got something, and we just telegraph to the investors, yeah, they're an LLC now, but they're going to convert, and don't worry, we've got all that ready to go. If you're loose on customer contracts, it's a time to get tight on customer contracts. If somebody developed IP for you and you never had them sign an invention assignment agreement, now's the time to go back and say, hey, looks like we missed a piece of paper here. We need you to sign this, kind of getting your house in order. We give our clients also, so when investors come in, and I represent investors too, so I see both sides. Like I represent Pelion and Signal Peak and Epic and Kickstart and those funds in town. So we see it from that side as well. Sometimes we'll give our clients their standard due diligence request list, which is the request list you get from an investor once they're ready to really dig in. We'll give them that and say, now go sort of see how well you do. Do you have these documents? Can you answer these questions? And that's the time when you do it. You want to do it definitely before, not during a process. We've cleaned up plenty of messes in the middle. But optically, that's not great. It gets expensive. So we encourage our clients to do that ahead of time so they're nice and tight. And if there are issues you can't resolve them, and you just are ready to speak intelligently to what the issue is and why it's not a problem for your company.
One more question.
Hi, thank you for the talk. I'm right over here.
I can kind of see you.
Awesome. Yep. I have a question about the legality of when you're a student starting a patent, when you're working under a professor, and when you're filing that initial patent disclosure. There seems to be some gray area in how much the professor versus student is involved with those patents, and if you're required to list both as co-founders. Does that make sense?
It does, but you've got the wrong guy up here to answer that question.
Okay.
But I can speak to it generally. Every university has policies around things that are done on campus and who owns them out of the gate and how they ultimately can get out of the university and into the hands of you and your professor or some other group, and you need to know what those policies are. It depends a part on what your capacity is that you're actually developing the patent, for example, up front, or the IP that's covered by that patent. But yeah, every school is different in how they do it. But you're thinking about the right question.
Thanks.
Yeah. And good
Marc,
luck with your patent.
that was an appropriately diplomatic answer given the audience.
Thank you.
One more question, then we need to go to our next panel.
Is there such a thing as split co-inventorship when one co-inventor has like 90% of the rights, the other one is 10%, or is it always 100%?
On the patent?
Yeah.
Yeah, yes. I don't know. Anybody here smart on patents?
Scott Orion, he's still around?
No?
All right, we'll find the boys from Ballard Spar.
Find the boys from Ballard Spar. There they are.
Yeah.
Yeah.
All right.
Thanks for the question, though. Thank you, everyone.
Marc, thank you.